So let's talk about the first living document, and that is your general durable power of attorney. Probably there's a number of you in the room who are POA for somebody, the power of attorney for someone. If you're involved in any kind of long-term care situation, if you're helping out a loved one, anybody who lacks the ability to manage their own affairs, that requires a durable power of attorney document. Now, I call it a general durable power of attorney because this document typically covers financial matters. It typically is something that takes effect when it is signed. And if you have a general durable power of attorney in place, congratulations, that is an excellent step. Because if you went to an attorney and they said all you need is a will, they forgot to tell you about the most important document you need, which are the documents that you have in place while you're alive. So a general durable power of attorney grants authority to somebody else to manage your affairs. So for example, I have a general durable power of attorney for finances where I say my husband can take care of things if I can't. Now, does that mean that he is stepping in and doing all of this work for me now? No, because I still can. So the idea with a durable power of attorney is it grants authority to somebody else to take care of your affairs when you can't do so yourself. And none of us like to be in that situation when we think about when can't we do it. Well, when can't we take care of our own affairs? Well, it could be something as simple as a car accident, that's a short thing, or it could be something that is more of a progressive health condition. Obviously, we think of dementia, Alzheimer's, stroke, any of these really fun things to talk about that nobody wants to talk about, but they do happen. And estate planning is all about planning for the what ifs. I'm sure everybody here, including myself, would be very happy if at the end of the day when we pass away, nobody ever had to use the general durable power of attorney. That's what we all want. But statistically, probability-wise, that isn't really what happens. At some point in time, there may be a need for a durable power of attorney to step in. You might need to manage the affairs of your spouse. They might need to manage your affairs. Or it could be some other family member who requires help. Has anybody had to act under a power of attorney here in the room? Has anybody been a caregiver in the room here? Yeah. You know, one of the things that I think is really interesting is that there's a lot of assumptions made. We live in Washington State. We are a community property state. If you've been married for 50 years, you likely say everything that we have is ours, yours and mine. And because of that, and because maybe you have your bank account together, you think that you don't need a durable power of attorney over your spouse because they can manage your affairs. And unfortunately, that is not true. That's a false assumption. So especially with spouses, you each need to have a durable power of attorney where you grant authority to each other or to whomever you decide is that decision maker for you. So one of the key reasons, and I said that we'd be talking about the 5 reasons to get your worry-free estate plan in place. The number one reason is so that you choose someone you trust to act on your behalf if you can't do so. So we've talked about finances. So does anybody want me at this point to get into any more detail about what happens when a husband and wife don't have a power of attorney over each other? No? Okay.
Yes.
Okay, let me show you with an example for about what will happen. So think about when you last bought or sold your home or other real property. Do you remember that both of you signed the name on the deeds? If your spouse can't sign their name on that deed because they don't understand because of lack of capacity, then the sale can't occur. And what happens then is, if you don't have a durable power of attorney in place, you need to file a petition with the Superior Court and get guardianship over your spouse. And then, under a guardianship proceeding, it's a complicated process to sell your property. The court is involved every step of the way. They have to approve of this sale, and if you have a guardianship for the financial matters, there's going to be a guardianship over the personal matters, which means you need to file a personal care plan with the court, and it's reviewed every year. And you likely, if you have capacity yourself, will be your spouse's guardian, but you're still within the court's control. And what that means is even your own finances, even what you do, has to be laid out in front of the court. How do you spend your money? What's your budget? What comes in? What's the care plan? It is such an intrusive and disempowering feeling to have your and your spouse's affairs laid out in court. And you have capacity. Your spouse probably minds less because they don't have capacity. They don't understand what's going on. But you do, and you're in front of the court. That is the state's plan for you if you haven't done your own plan, which is to get a power of attorney. Does that make sense? I know it sounds awful, and it is awful. So if there was one document, just one, that everybody in this room had, my preference would be it'd be a general durable power of attorney, so that you never during your lifetime have to deal with the court supervising everything you do. I've been talking about financial matters, a durable power of attorney for financial matters. And you can see from that slide, it's to sell what you have to sell, whatever you have to do financially. We want the durable power of attorney for finance to be very comprehensive so that you can do whatever you need to do. And then some people might say, well, I don't want to grant that authority to somebody. That's just too much. That makes me uncomfortable. I say to them, then you've chosen the wrong person. Choose somebody you trust with your money and your life. And if you don't have that person in your life, there are professionals who will serve. But you need to select somebody who you know will uphold their what's called a fiduciary duty to you to do right by you. So select the right person, and then don't stop there. I say I appointed my husband, then after that is my daughter, then after that is my son, heaven help me, and then don't go beyond that.